Roll call?
Chuck Beckman, not present. Ben Forster,
Present.
Ellen Smith,
Present.
Emily Pratt, not present. Chris Jones,
Present.
Amy Palmer.
Present.
Okay, moving on. Last meeting, we did not have a quorum to approve the meeting or approve the minutes of the June 3rd, 2024 Lee County Regional Planning Commission meeting. Have you had a chance to review, and do we have a motion to approve?
So moved.
Can I get a second?
Second.
All in favor, say aye. Any opposed? Carries. Also before us are the minutes of the February 3rd, 2025 meeting held at 6:30 PM of the Lee County Regional Planning Commission. Can I get a motion to approve?
So moved.
Can I get a second?
I second.
All in favor, say aye.
Aye.
Any opposed? Carries. All right. Do we have any old business?
There is no old business tonight.
All right. Hearing none, we'll move on to new business. It appears on the agenda, we have one item, petition number 25 PC 78 by the Lee County Zoning Administrator. It was filed in which the petitioner seeks to amend the Title 10 zoning regulations of the Lee County Code of Ordinances to replace Zoning Board of Appeals with Zoning Hearing Officer and to create standards for amending special use permit that may have been previously approved by the Lee County Board. I believe at this time we'll move on to swearing in for testimony. Alice Hinkle, do you solemnly swear or affirm under penalty of perjury that the testimony you are about to give shall be the truth?
Yes.
Okay. Let the record reflect that Alice is sworn in.
Okay, good evening. Just a little bit of background here on the petition that is before us tonight. Lee County is exploring taking a different direction in that they are looking to replace the Zoning Board of Appeals with a zoning hearing officer. We cherish our Zoning Board of Appeals. However, there have been some things in the last few years not related to the zoning board that is kind of driving this change. One of the biggest factors that we've had to deal with is conflicts of interest. We are in a small community, and finding board members that can serve that don't have conflicts of interest is difficult. The second challenge we face is perceived conflicts of interest. Now, these aren't actually conflicts of interest, but sometimes the public will perceive a person to be too close to a petition where they personally feel that the board member can't be unbiased. So this has had a negative impact on some of our public. So additionally, zoning is a very legal process. It's a law that we are enforcing. These ordinances are getting more and more complicated, as we've seen with the changes to the wind and solar. We brought in a hearing officer to help assist the ZBA through those processes a number of years ago because of the legality involved in these hearings. Additionally, a lot of counties are now facing litigation regarding zoning petitions. So by adopting a zoning hearing officer who would be a licensed attorney who's licensed to practice in the state of Illinois, we're hoping that it'll bring a more black and white process where we're taking away the perceived conflicts or conflicts of interest, that we have somebody who can read and understand the law and can make decisions based on that law. So with that, we have drafted some language, and I'll take you through that tonight. I've paper clipped your pages that are the most relevant because it is a rather large document. It includes the entire zoning code because we had to change throughout that entire ordinance. In the first section, which is definitions, we have removed the definition for zoning board of appeals. And that would be on about your 9th page. I'm sorry, the pages aren't numbered. That's why they're paper clipped. Then a few pages after that, I believe about page 26, we added the definition for zoning hearing officer. That definition reads, zoning hearing officer, an attorney who is licensed to practice in the state of Illinois, who is duly appointed by the county board to conduct hearings on zoning matters, including variances, special use permits, and appeals of administrative zoning decisions, and to issue recommendations as prescribed in this code. This term shall include any duly appointed alternate zoning hearing officer of Lee County. We go forward a couple of pages. You can see where the red lines indicate where we're changing out. Everywhere there is zoning board of appeals or board of appeals, we are swapping out with zoning hearing officer. Jonathan, can you pull this up on the, I'm sorry. I'll have you go to page 28. Now we'll kind of get into the meat of the language, first starting with the zoning hearing officer. As you can see with the red line version, essentially we are removing all the language related to the zoning hearing officer, or I'm sorry, the zoning board of appeals. So in its place, I'll read you what we are providing. So it will be 10-2B-1 will be the establishment, appointment, and term of office. And that reads, A, establishment, the position of county zoning hearing officer is hereby created in accordance with 55 ILCS 5/5-12015. This is allowed by the state statute, and we have referred to that statute while writing this text amendment. Letter B is appointment. The zoning hearing officer shall be appointed by the county board following recommendation by the designated committee of the county board. Such appointment shall be confirmed by a majority vote of the members of the county board present and voting thereon. The zoning hearing officer and alternate zoning hearing officers shall serve at the pleasure of the county board. Alternate zoning hearing officers shall serve when the hearing officer is not available. Vacancies in the position of zoning hearing officer shall be filled expeditiously and in the manner herein provided for the appointment of such officer. In section 10-2B2, it was the jurisdiction and powers of the ZBA. This section is now the duties of the zoning hearing officer. We didn't really change any of the language. We just substituted zoning hearing officer where it had zoning board of appeals or board of appeals. If you go to the next page, I'm going to have you skip ahead to, let's see, should look like this. At the bottom of the page, it should say Article C, Regional Planning Commission. Okay, this is where we continue on with the duties of the zoning hearing officer. The pages that we just skipped over have to do with the amending special use permits, and I'll come back to that once we finish the zoning hearing officer discussion. So in 10-2B-3, it's was changed from meetings to meetings and rules. Since a Board of Appeals required quorum, we were able to remove that section. It basically aligns with what the Zoning Board of Appeals was required to do, with the exception that no quorum is required at this time. So that is, briefly, that is the language addressing the appointment of a hearing officer as opposed to a zoning board of appeals. Are there any questions on this section? Okay. So if you go back to the page, can you see that? Scroll back up. It should have number 4 amendments to special use permit. Yep. Okay. All right. Up on the board, he's got this section that we're going to look at that might help you find where we're going back to. So currently, our ordinance does not provide a path for amending special use permits. We can pass them, but if somebody needs to change something regarding that permit, we don't currently have a way to do that. And we could possibly have some projects this year that will require it. What this language is meant to do is, first of all, the special use permit, if they want to amend it, it first has to be approved by the county board. So it can't be anything that's pending before the county board. If they want to make changes, well, a petition's pending, that's a whole different situation. So this will allow them in certain situations to come back to the county and say, hey, we have something in our project that has changed. And our project will not be viable without this making concessions for this new equipment or new technology or whatever it may be. We have a couple of, right now, solar projects. They've been caught up in PJM, which is our regional transmission operator. They're the ones who control what energy goes on the grid and what energy goes off the grid. We've had a number of solar projects that have been stuck in PJM's queue now for several years, and we're starting to see movement. Unfortunately, with limitations at substations, some of these projects may be required to build transmission lines to get the power from their project onto the grid. If they didn't disclose transmission lines as part of their project initially, how am I supposed to treat them going forward? Their project's not going to be viable without these transmission lines, but we don't want to make them go through the whole process again. So we've created language that will help some companies, and not just the solar companies, anyone that has a special use permit that has something change can come back and ask the county to amend it. Do you want me to read it to you guys? No, okay. So the purpose and intent of this section is to establish a procedure by which an applicant may seek to amend an approved special use permit in order to address changes in design, conditions, or other factors relevant to the underlying special use prior to the issuance of any building permit. So once they get their building permit, it's too late. They can't come back in and say, now we want to change things. So this has to happen after the county board approves their special use permit, but before they obtain their building permits. It goes on to explain material change and minor field adjustment. So a material change is something that's going to substantially alter the project. The minor field adjustment is something that's, it's a change, but it's not going to have the same impact as a major change. So one of the companies that I'm dealing with, the ZBA created a condition that is creating conflict with their contracts with their landowners. So they would like to come back in to seek to amend that so that it aligns with their contract and doesn't create this conflict. That might be something we would consider a minor field adjustment because it's not going to have it's not changing the design of the project. It's not going to, the public's not going to see any impact. It's more of an internal change that is affecting their project. So the initiation of the amendment, they're going to have to apply similar as they would for a new petition. The cost will be, similar to what we charge now, but probably a little bit less than a full petition hearing. Classifications of amendments, the minor amendment, so slight shifts in building placement, changes to landscaping or buffering, adjustments to parking lot layout. Major amendment, any amendment deemed by the zoning administrator to be a material change to the original special use petition or that may significantly impact surrounding properties shall be treated as a major amendment and processed according to the procedure in subsection F below. So they'll come to my office and I will be the deciding factor as to whether it is a minor change or a major change. If it's minor, it's something I can handle in my office. If it's major, it's going to have to go through the hearing process. Correct, because it's going to involve more parcels of land that previously weren't disclosed. So the impact to the public has now changed because we're going to be creating adjacents that weren't adjacents prior to the transmission line. So I would say yes, I would consider that a major change. The next section takes you through that hearing process, public hearing, the notification requirements, the requirement for having a hearing facilitator or hearing officer, and then the decision by the county board. It further goes out to spell out the standards of approval. So it will give the zoning hearing officer a guide as to what they will need to consider when considering requests to amend special uses. The next couple of sections, effective approval, the revised special use permit upon approval of an amendment, the applicant shall receive a revised special use permit or an amendment letter from the Lee County Zoning Office, and conditions of approval. All previously imposed conditions not expressly modified by the amendment shall remain in full force and effect. ZBA has the ability to add conditions to a project for special use permits. The zoning hearing officer would have the same ability if that's the way the county goes. Conditions are special rules specific to a project. So because of an area or because of a nuisance that might be created, the county can create conditions to offset things of that nature. So if we had a special use coming into an agricultural area that was going to create some sort of nuisance, we could require screening or additional setbacks. We do have to be careful, though. We can't create conditions that would stop a project from proceeding. So what this is saying is that even if they come back to amend it, those conditions that were originally established through the special use permit will still exist. But they can change and add additional conditions or amend conditions to make them more effective. Standing passage requirement, the owner or owners of parcels immediately touching or immediately across the street. So this is actually from the state statute. This gives people that live near special use projects a little bit more say. So if they band together and they file the necessary objection, that can force a supermajority vote by the county board, whereas they'll have to have a 3/4 majority for any amended special use permit. That is also available to the public under a special use, the original special use request. So we just carried that over to this. We did discuss the restrictions on withdrawals of concessions. This is kind of important because during public hearings, a lot of companies will make promises, guarantees, things of that nature that we expect them to, live up to what they said. So if they say something in public hearing and say, yeah, we're going to guarantee that the public is protected by doing X, we are going to hold them to it. So amending the special use permit does not change what they agreed to in that initial hearing. So we wanted to make that clear. We don't want the public to think that this is a way for these companies to come back and get around rules and regulations. Lee County is going to be holding them to what they said. And that is being reinforced in this language here tonight. A revocation or lapse, this applies to special use permits and now amended permits, that if they have repeated violations of their permit, the county can move to revoke their special use permit. We also allowed for appeals. So if somebody disagrees, say they come in and they say, we would like to amend my project. And I said, well, that's a major modification. And they say, well, I disagree. I think it's a minor. They can appeal my decision, and that will go before the zoning board of appeals or the zoning hearing officer, who's ever in place at that time. And then severability is just some legalese to cover our bases. And that concludes the recap of the language for amending special use permits. Does anyone have questions about that? Yes. Can you speak in, turn it so it's green and speak in, otherwise they can't hear you on.
Okay, I wanted to ask a question about the new hearing officer.
Mhm.
Who's their watchdog?
The zoning hearing officer, so as of right now, the state's attorney's office is in charge of the hiring. So I would imagine it'll be the state's attorney's office and then myself as well, because I'm going to have to work closely with them to get these petitions, keep them moving and whatnot.
And he's completely replacing this board? That person is?
Not this board, the zoning board of appeals. They meet on Thursday nights.
Oh.
So they're different. They hear zoning petitions and appeals. So anytime anyone appeals my decision, it would go before the zoning board of appeals. So not replacing you guys, it would be for the zoning board of appeals.
What do you view the pros of the zoning officer format versus the zoning board? And what do you view as cons?
So the pros are the black and white. It kind of takes some of the emotionality out of the hearing process. Which I like because I'm just that kind of person. I'm a black and white person. So that to me would be a potential benefit. The conflict of interest discussion is one that it goes round and round and round. This hearing officer, it's probably not going to be able to be a local attorney. We want someone that is removed, that we don't have to have that concern, but we also want somebody who's familiar with the area and what kind of community we have here in Lee County. Some of the cons, we're taking your citizen board members out of the equation. So we're going from 5 perspectives down to 1. So that is a little concerning. Only in that I don't know how that's going to play out. It might streamline the process a little bit better. But I have no guarantees. So really, I think there's a lot of hope for what they think they are going to get from a zoning hearing officer, and we really won't know until that they come in and we actually see how it plays out. I know a number of our board members have talked to Whiteside County. I guess they went to this format and they had nothing but good things to say about it, that it really streamlined their process, just kind of took a lot of the emotionality out of things, just makes it a little bit cleaner is how they feel. And they are also dealing with litigation, so they were trying to address that concern as well. So it really doesn't answer your question.
No, it answers my question.
Okay.
There's pros and cons to both sides. So, in discussing the pros and cons of a zoning hearing officer, you also discussed the pros and cons of the zoning board, which I understand.
Mhm.
Um,
And that's the thing, with losing the zoning board, and particularly some of the members have years, decades of county knowledge. So we will be losing that if we go to a hearing officer.
so if you go to a hearing officer, is it still a similar format that it's held at night at a time when the general public can attend,
Yes.
ask questions?
My goal is to keep the public involved, and to do it at a time where the public can be involved. I don't want to make any changes to the format. It really does work. Judge Slavin kind of helped build that process out in helping us over the years as the hearing facilitator. So I think the process is good. It's just going to reduce it from 5 now to 1, but I don't see anything else changing.
Okay.
Is there generally a lot of public participation in the meetings?
Yes. It's hit or miss. Some nights we have 20, 30. Other nights, none. So it just depends on the topic. A special use is a use not typical of a district. So anytime you bring in a special use, you're going to see some type of response typically from the public in that area, because you're bringing in something that is not compatible with what they're used to. So it's expected. Unfortunately, with the governor setting the state siting standards for wind and solar. It really eliminated the public say in those matters. But in any other special use, I mean, public involvement is imperative. The county does not know how to, which way to go if there's no one here to say, we like it, we don't like it. So I do as much as I can to get the public involved, to make them aware, because it always happens that after the fact, somebody will say, well, what about this? And unfortunately, with the hearing process, the county board can only consider evidence presented during the public hearing. So if those people don't show up to the hearing and then tell a board member after, they technically can't use that information in making their decision. So public involvement is critical.
Has there been any discussion with Whiteside County, with those that have talked to them about this process and having a hearing officer on maybe cost? How much it would cost to have an attorney? And you said it would have to be an attorney not from around here, so you would have to have a per diem for that attorney to travel. And of course, attorneys aren't cheap to start off with, and we're going from 5 everyday citizens that are, making a little bit to be here to a full-blown attorney with a law degree. I mean, has there been any discussion about that?
Yes. So we've looked into the budget currently that we have for the Zoning Board of Appeals, and our attempt is to work within that budget so that there will be no increased cost to the public, to the taxpayers as part of this. So we are looking at, is it going to be a per diem? Is it going to be like a yearly salary where they get X amount per year, but they're obligated to show up, at least 12 times. That's where the state's attorney's office is coming in to try to cobble something together that will draw in effective attorneys, but keep us within our budget.
I think the challenge is the wild card of the citizen general population having the emotional investment into this process when it comes to wind, solar, and the projects that are, quite frankly, out of our control.
Mm-hmm.
And having board members, county board, zoning board, regardless of what the board, voting against the interests of the county from a legal standpoint. Would there be value in only those types of projects that open the county up to potential litigation or liability to be managed by a zoning hearing officer, yet maintain the zoning board for the everyday stuff?
That was considered, and essentially that's what we have been doing for a number of years now with Judge Slavin and attorney Tim Zollinger as of late. So that was considered, and I don't know where the shift occurred. I'm more or less just the messenger.
I understand.
So I know that was considered, that's kind of where we're at. And even taking that into consideration, the county is still interested in going to the hearing officer.
Okay. How do you remove the subjectivity of the hearing officer? I understand they're getting to the roots of finding a fact, but how do you remove their subjectivity? When you have a board of 5, you have a board of 4, whatever. You're allowing different perspectives that are familiar with the issues. I mean, we've seen people show up here that aren't familiar.
Yes.
So people that have either sat on this board or a zoning board or other boards have seen other instances where you have an attorney with a basic perspective on life, or we bring 4 or 5 different perspectives to the table. We come from different walks of life. We come from different industries. We come from different parts of the community. How do you bring that in with a zoning hearing officer?
I think that's where public involvement's gonna have to play a role. I can't answer
But-
that, I guess.
I understand the challenge because, the goal is streamline the process, work within the confines of the law, limit the liability of the county. But how you bring that in other than what we typically see in the gallery if there is an emotional subject.
It's still going to, I guess I don't see. So the zoning board of appeals on an emotional topic, so wind, solar over the years. The petitioner gets to present their petition. That witness gets cross-examined. They present any other witnesses, they get cross-examined. And then the public gets to present evidence. And then they get to give their closing statement. So that's not going to change, I guess. So we're still giving the public a voice. And I think that is where the hearing officer will probably have to work with me on some of those more sensitive issues to get the perspective of what's occurred in the past, and where the county would like things to go currently. So I guess maybe I'm going to be that bridge. But I guess I'm not sure.
So in the case, let's get past the mega corporations and the projects, the solar projects, the special use stuff. What about your average citizen that's got a zoning position? And you have one person that is the hearing officer, and what if they just don't like it?
The county board still has final say.
Understand?
So say,
Or that person really likes it, it's a good idea, but everybody else in the galley is like, yeah.
they're gonna have to remain impartial and stick to the code. And that's really, I think, the main focus is making sure those processes, that we make sure we meet all of our processes to keep it legal. So that we're meeting, so we're abiding by the Open Meetings Act. We're guaranteeing that people are getting their chance to present evidence, cross-examine, closing statement.
I mean, I do see the value in the solar projects, the mega projects, the infrastructure type projects, but I want to change zoning on my business. Owen's my neighbor. She doesn't like whatever product I have because whatever. And the zoning administrator is going to bring bias to a situation like that.
How so?
Life experience, okay, I have horses. That person was traumatized by a horse. She doesn't like my horses. That person thinks horses shouldn't exist. Or that person thinks cow farts are detrimental to the environment, where 4 other people don't.
But that's where I think, I mean, you're gonna have to go back to the code. It all depends on the issue. So if the complaining neighbor doesn't like something, well, it might already be allowed by the code. So the neighbor doesn't want a pig farm coming in next to their farmette, but they live in the ag district. There's not a whole lot we can do to stop ag in the ag district. But we'll still be able to hear those concerns. And I mean, they're going to have to be able to differentiate, and I might be the one that has to assist them on what is accurate and what is not accurate.
Because currently the zoning board makes a recommendation to the county board.
Yes,
Is this hearing officer going to be making a recommendation?
yes. With my help is my understanding. Excuse me.
So if you have two emotional people on a highway charge subject, that's a gray area. What does it come down to? For a recommendation?
Maybe. Or, I mean, like we saw last time, last month, the zoning board ended in a 2-2 tie. So
Sure.
that goes forward without a recommendation. So the hearing officer could ultimately send on without a recommendation to approve to the county board. If they didn't want to weigh in, I guess, and pick a side. But I think that is the part where I'm going to come in and say, and make recommendations. So given the neighbors' concerns about this, whatever issue, we should maybe create a condition that, they have to give an extra 10 feet setback. I guess it's just really going to depend on the situation, what laws are in place at the time that impact whatever their concern is. So I don't know if I can really answer that without having a specific example.
Until it hits you.
Yes,
Until
exactly.
it comes before you.
Exactly.
And I guess my other reason for pause on that would be this zoning administrator establishes their own procedures and rules.
So the rules and procedures of the zoning board of appeals are already established.
But in the text amendment here, it says this person shall create their own. What if you get somebody that really sucks at their job? Is there a provision to remove them?
Well, that's a good,
And how do you do that?
County board can't just fire them?
Would be the state's
it's,
attorney, wouldn't it?
it's
You're
better
dealing
to
with an
have,
attorney for a wrongful termination?
right. And he's right. We should have a process for removing or replacing.
Well, didn't you say the state's attorney himself was gonna be the one hiring him?
Yes, but we still should put something in the language that if a situation were to arise where we needed to remove somebody, that it's very clear what the county can and cannot do.
And is there a term limit?
No. The idea is to have, if possible, a minimum of 2 or more. They also intend to keep Judge Slavin and Attorney Tim Zollinger as hearing facilitators for wind and solar as an option. So people will be able to have the choice of who they want to hire for those specific petitions. Their statute requires that they pay those fees directly. So it's a little bit different than just your everyday special use.
Hmm.
Well, it's like when we elect a judge, after a few years, we get to vote if they get to keep their job or not. Shouldn't the county board be doing this with the zoning officer as well?
It's a great question for them. I will relay it to them.
Chris, I didn't understand what you were saying.
Well, Ben brought up term limits, and when we elect a judge to their position, a certain amount of time, it comes up on the ballot that we get to, that judge is either doing a good job or a poor job, and the public gets to vote if they get to keep their job or not. I mean.
You
that
vote
would
to
be-
retain.
Yeah, and then
Or
that would be
not.
something like we could present in front of the county board. And so if the county board has heard complaints from their constituents about how this person's doing, they could vote to keep them or choose a new one.
So the board before, were they just appointed by the county board?
Yes. And they didn't have term limits either. How frequently, Chris, would you propose that the county board make that review?
Well, on average, how many cases are brought in front of the ZBA per year? They meet.
I would
by
say a minimum of 12 for
At
sure.
least 12. Well, I mean, I'm not too sure, about probably 2 years.
Okay.
I mean, 24 cases, that gives you a good pool to draw off of on.
Well, but it's also, I mean, even yearly.
Yeah, well, yeah, could
You
do
know,
yearly.
They have
Yearly
enough
performance
committees and
review.
agenda items, they can slip it in somewhere.
Yeah. Well, I mean,
View
that,
County Board,
that goes back to eliminating 5 citizens that live in the county that actually hear from their constituents and interact with them. And it allows the county board to interact with their constituents and hear how this administrator is doing. And, you know, make recommendations or replace or however they see fit.
that would get me more on board with it.
Term limits and reviews?
Term limits, reviews, and a removal process.
Okay. One other thing, we did do some minor cleanup throughout the ordinance. A lot of them had the masculine pronouns. We just went to a gender neutral pronoun. And then the other change that was made throughout was we eliminated the zoning compliance officer being called out in the code. So according to our code, the zoning administrator and the zoning compliance officer can be one and the same. I currently have a zoning compliance officer working for me part-time, and him and I are not the same. So we had to go through the code to separate that language to make it clear who has authority over what.
Okay, I don't know if this helps or not, but I found where it says, I could have sworn I read this. The zoning hearing officer and alternate zoning hearing officers shall serve at the pleasure of the county board, but that doesn't. It doesn't give a term or anything, so I guess not.
We probably want to prevent the county board of, hey, we don't really like this person, but we really don't know how to get rid of them. And then 6 months down the road, they're still trying to figure out, well, maybe we could do it this way.
Clarifying it would be a good idea.
If it's clarified, if it's on the paper, you got to process.
Yes. If there are no further questions for me, and there is no members of the public here to present evidence or cross-examine or give closing statements. Unless you have more questions for me, you would be able to proceed with making a recommendation.
Okay. So it's motion time. And we can make a motion however we feel we need to. So we discussed 3 different items in our just general discussion. I've got removal, term limits, and also just retention process, retention and review. We are making a recommendation to the county board of how
To
we'd like-
approve or deny the petition.
Okay,
And the one other thing that you brought up was oversight of the rules and procedure.
okay.
Okay.
So right now you're looking for a hard up or hard down right now.
It's,
You-
those
You're
are the
looking
only two
for
options I'm aware of.
Approval or denial of what's written before us
So you can,
and add recommendations.
yes.
Okay,
So you could say, we recommend that it be denied as written, but we would recommend it be approved if XYZ was considered.
okay. So let's do this formally. Let's put it to a vote on recommending the text before us. Do I hear a motion to recommend it to the county board as it's currently before us? If I hear none, we'll move on.
I think you made, we all, but you especially made a number of good points, and it would be much better if they were incorporated.
So do I hear so let's take a vote. All in favor of approving and recommending this text to the county board as it's written, signify by saying aye. All opposed,
Aye.
same sign. Okay.
So we probably want to make some recommendations.
So I would entertain motions for recommendations to the county board. Do I hear a motion? If you can read my writing.
Well,
Okay, so I move to make a recommendation to the county board for text that would incorporate the removal of the hearing officer, the possibility of term limits, also the possibility of retention and review hearings, and vote to extend a specific hearing officer in their term or to terminate. And also recommend an oversight of the rules to make sure that the hearing officer is complying.
Do I have a second?
second,
All in favor? Signify by aye. Any opposed? Motion carries. Are there any other motions related to the subject at hand? Okay, hearing none. Do we have any other new business?
No.
Okay. Do I have a motion to adjourn?
so moved.
Meeting adjourned.
Second.
A lot of good points.
Thank you, guys.
What community